One civil society activist in Kenya has obtained nearly 30 court orders, ex parte, 30 court orders, ex parte, from the court. He walks in, he gets an order, comes out. He walks in, he gets an order, comes out. In fact, he could even walk in today and say he wants an order so that all cabinet secretaries commit suicide. You'll get the order.
Through the Chief Justice who is with us today, I also urge the judiciary to do their part to ensure that orders are not frivolously used by individuals to avoid justice.
President Uhuru Kenyatta there talking about the judiciary and their role and the kind of orders that perhaps would be expected to be coming from that arm of government. Earlier, we've also heard from Interior CS Matiang'i expressing discomfort with some of those orders that my guest is who he appeared to be talking about. One of my guests is able to get time and again, as he highlighted. And I want to introduce my guest to you tonight. Joining me on my immediate right, Okiya Omtata is an activist. Thank you for being with us. Professor Peter Kagwanja, Chief Executive, Africa Policy Institute. Asante Sana, and Advocate Apollo Mboya. Thank you all for making the time. I'll begin with you, Omtata. And you've heard that's the Interior CS talking about your ability to get this ex parte orders, just you being one party being heard by the judges without the other parties involved. We also saw the Chief of Staff also highlighting the same on his tweet. So what would you attribute this success rate to? Because they appear to read other things.
I think they should just go ahead and obey the law. What they are doing, and the reason why we give these orders is that they are not obeying the law. And if they obey the law, then it will make everybody's life easy. But particularly for Matiang'i, he did not tell everybody why he was so angry. It's because I stopped him from stealing from Kenyans. The GSU land, he has disobeyed an order I have.
Allegedly?
Not allegedly, it's a statement of fact. Okay. I got an order on 13th of December 2016 from Justice Boss Onani, Justice the Principal Judge of the Land Court. Congo, from Justice Congo.
Yes.
Stopping any transaction on that land.
Okay.
And they went ahead and they did those transactions. So I'm after him for contempt of court. And they have stolen money from Kenyans. So you cannot come around and say that I get orders frivolously. To get an order in our courts is a very difficult thing. You have to do a lot of work. You have to do a lot of research. You have to align your facts. And then you have to, the judge has to be convinced. It's not something that you walk in and walk out. Mm-hmm. And in fact, I think out of 10 cases, you might get an order in one or in none. So I don't see what he was stating was not really true, but he was angry with me because I have an order which they disobeyed and I'm going after them.
Okay.
Over the GSU land in the Ruaraka.
Right.
Yeah.
Professor, in the executive, they appear to have a discomfort, and they've not made it a secret that specifically for Okiya, the times he's moved to court, that he gets all these orders in his favor. Do you share that discomfort?
Yeah, the discomfort is there. I have no reason not to share or to share at a personal level because I'm not in the government. But what I do know for sure is that since 2010, Okiya Omtata is perhaps over-dramatizing the citizen. Over-dramatizing the citizen in the sense that one wonder, where he gets not just the energy, but even the kind of support he has. Because developing a case, and Attorney is here, and pushing it in court, getting 33 means that he has stronger power or capacity, if you wish, behind him, which makes everybody wonder how has he transformed himself into an institution that dramatizing this citizenship, and why is he so favored in court? I know there are a number of other young people who've been trying to do that. I don't want to mention names, but they have not been as successful as Omtata. And therefore, Omtata is a citizen, but a citizen with very curious credentials.
All right, with curious, I'll allow you to rebut before I come to Apollo because...
What I'll do, like the latest order I got...
Yeah.
Over the president, if you look at what the president said on Madaraka Day and what Kenya was purporting to do, it's like day and night. The president understood the law and he said, I would like ABCD to be vetted, and upon being vetted, those will be found unsuitable to serve will be given marching orders. The president never said he wants anybody to be given marching orders. Then you find, and I have the statement here, it is 3,103 words. I've read each word of them. And nowhere does the president ask for anybody to be fired. Then Kenya wakes up like he has smoked something. Then he issued a circular which is totally subversive of what the president had said. He begins saying people...
But he's acting for the president.
No, but you cannot act for the president when you are doing something that is the opposite of what the president said. What the president said is totally covered in law. What I expected Kenya to do is that the president has given us a target. So what we need to do, first of all, we don't have a legal framework for vetting. Like when we vetted judges, we had a law. When we vetted the police, we had a law. And we vetted them as they continued performing their functions. So instead of Kenya going ahead to develop a legal framework through which you could vet people, which is a good thing, he declares that people are being given marching orders. They are going on compulsory leave.
For 30 days, pending
for 30 days, pending whatever.
The law is clear.
Before you respond, let me bring in Apollo, who we need to get his views as well. Several things have been put out here. First, as an advocate and knowing what it takes to prepare for a court. You've heard what Prof has said regarding Okia being an institution and the capacity he has. Is that something that stands out for you, or is it something that in the legal fraternity is very normal?
Because I know Okia Omtata, and Okia Omtata consults me a lot, among other people. And I find it also very strange and very curious for Professor to say that Okia has got curious credentials.
No, not credentials.
Yes, that's the words he has used. But Okia Omtata is exploiting a gap that is there, that has been created by the new constitutional dispensation. Not very many lawyers are actually taking up public interest cases. I do a few of them, but I know Okia goes extra mile and he consults lawyers. And with time, he has actually mastered how to handle public interest issues, which many lawyers are not taking up. And it's a challenge to the lawyers to take up more public interest cases instead of focusing on only bread and butter issues which goes into their pocket.
Right.
Yes.
So you wanted to say something?
Yes, I just wanted to say, I'm not, by the way, I hope, Boya, you got me right. Omtata is my friend, so I wouldn't come here on the studio to work. We are here on public interest. That's the spirit within we are talking. I'm familiar with the Kituo Chaseria. I'm familiar with all the institutions that had come to champion public interest. And I know the problems they went through in terms of capacity, funded internationally and otherwise. So what I'm marveling about, what I'm calling these curious credentials and curious capacity is how Omtata is able to prepare a 100-page document. I've been in court when he is there, and he's flashing out a paper after another when very seasoned lawyers are unable to prepare their case and are pleading to be given time to prepare. And here is Omtata flashing everything. So I'm wondering, where is Omtata getting this huge capacity that some of us who are heading charitable organizations like Africa Policy Institute are not even able to do, with all the funding we are able to summon. So this is what is really causing, some questions within the government.
You think, would you then say with those in government saying that the judiciary is being used to protect some individuals? So you're saying he has a soft
front for a very hard behind.
Omtata. And this is definitely not a conversation around your person. But at the end of the day, clearly, time and again, the government is alluding to some of the things you're able to do when you move to court and arguing that it's frustrating their fight.
I think they should tell us, case A, the issues were these, Omtata got orders. Let us get an example. They were restoring the police 99 line, which had been dead for long. I fought that thing. The AG fought me to the hilt. I won the case. Who launched the 99? President Uhuru Kenyatta. It's one of the Jubilee achievements, you see. There was the case of the police, this thing of a police surveillance system. I saved this country 20 billion shillings. who
So
took the
the government
credit.
should appeal,
So-
raise their issues through
No,
the
they
legal
should,
system.
before they come talking here, they should give us what are the merits of these cases that are saying, I get orders here and there.
Okay.
I prepare my cases, I choose my fights, and I...
On this procurement, chiefs, for instance, stopping the vetting, you chose and picked this matter, or did some of these procurement chiefs approach
I don't
you
even
to
any of them.
support?
I don't even a single person.
Yeah.
I picked this matter up, and my concern was that I listened to the president's speech on Madaraka Day, and I supported what the president said. But what his officers were doing was not what the president said. The president said what was in law. I want these people to be vetted, and those who will be found unsuitable to serve will go. Vetting does not require vacation of office. You are vetted as you are in office. It's when you are under active investigation for a specific crime with particular accusations that you vacate office to allow for the vetting, and that was even provided in law to allow for investigations.
Yes,
So when you show a judge that this is the speech of the president, and this is what Kenya has done, and it's totally opposite what the president has done, you put it as simple as you can. Why shouldn't the judge give you orders?
Apollo, let me ask you this. One of the big concerns has been around the ex parte, which is one party being heard and an order being issued, and that when it's a weighty matter with this kind of import we're seeing with the affected officers, shouldn't both parties be heard? In what circumstances is that situation allowed?
First of all, let me correct an impression.
Okay.
Not all the orders I get are ex parte. I've got so many.
In this particular instance?
No, just this one was ex parte, but the orders I've gotten, the weighty ones, have been inter partes.
Okay.
For example, that's issue on this issue which we had about the spying gadgets on telephone communication networks.
Yeah.
It was an inter partes hearing.
Okay.
So I get most of my orders through inter partes hearings, and today in the High Court today, you will hardly even get orders at the inter partes stage.
All right.
They don't want to hear certificates. They want to hear the petition, the main thing.
Apollo.
Yes, ex parte orders are granted to preserve the subject matter of litigation. If at all that litigation will be rendered nugatory, if that matter is not preserved, then the court normally gives ex parte orders just to preserve the status quo or the subject matter of litigation. And those ex parte orders are not in perpetuity. They'll give ex parte orders and then give a hearing date. For example, you can be given an ex parte order only to injunct a particular issue for 7 days, for example, so that you can serve the other side, and then you come for inter parte hearing. And when you come for the inter parte hearing, then, and having been heard both sides, then the court also has got discretion, the judge, to then extend the orders for another period or until that matter is finally disposed of.
Okay.
Yes.
Prof, there are those who feel the executive is in a sense trying to corner the judiciary to act a certain way, rule a certain way, for them to be seen to be supporting the war on graft.
No, first and foremost, let's appreciate this, that what Comrade Omtata epitomizes is what you call the Robin Hood spirit, the initiative of the commoner to serve the good of the role, those who are not as privileged. And of course, a democratic society like this one cannot kind of demonize that or undermine that. That spirit needs to be encouraged. I think what the government, from my understanding, is worry about is the weaponization of the courts. In other words, the courts, in whichever way you want to interpret it, have become weapons in political games. And this is something that started before 2010. The elites have used every space in their battles for political supremacy to undermine or support. They have used every space, from our ethnic identity to religion to everywhere, and the court has not been immune. If you look at the judgment that was passed on the case of Uhuru Kenyatta's election, Jubilee is convinced beyond any doubt that that was the climax of the weaponization of the court in the elite wars. And unfortunately, Comrade Omtata is caught in so many of these weaponization cases. And it might
And when the government and executive officials disobey court orders, they are not part of that
because
weaponization?
they are not disobeying. In fact, in one case, I think Minister Matiang'i was saying that he was not served. And I think even the chief of police was saying they was not served. Because some of these things are obtained at night. That's what I'm told.
No. We're going to continue with this conversation.
The only order that was obtained
the orders
at night
are obtained at night.
We must take a break.
The only order that was obtained at night was when the Court of Appeal mysteriously sat on a public holiday to allow the elections for 26th August.
Yes.
And it was a subversion of the judiciary.
Sure.
All right,
for which
gentlemen.
should have been sacked.
Gentlemen.
That's why we are saying
Yes,
the court has gone beyond its call of duty. If it is meeting at night at the prodding of certain people, then and the executive itself has closed its door for the day, and the court is meeting up to midnight to hear Omtata and others, then there was
I wanted to go on break.
No, it's not me.
That was doing that.
Gentlemen,
by the way,
let's please take a break. We have to pay our bills here on KTN News. When we return, we'll also get into the other judgment that was made around the NYS suspects being denied bail. Is it a tough stance, or is it an abuse of the rights of those suspects, as has been argued by various camps? Please stay with us.